Preemptory norms, jus cogens, and obligations erga omnes describe the highest level of legal obligation recognized in contemporary international law. International law is normally based upon consent between states, expressed through treaties, customs, and general principles. However, certain fundamental rules are understood to bind all states regardless of consent because they protect the basic interests of the international community as a whole. Jus cogens refers to preemptory norms of general international law from which no derogation is permitted. A rule reaches this status when it is accepted and recognized by the international community of states as a whole as fundamental to the international legal order. Any treaty or legal act that conflicts with the preemptory norm is considered void. Closely related are obligations erga omnes owed toward all. These are obligations owed not merely to a particular state, but to the international community itself. Because such obligations protect collective interest, all states have a legal interest in their observance. These concepts help distinguish between ordinary international obligations and those considered foundational to humanity, peace, dignity, and lawful relations among states. In practice, preemptory norms influence the validity of treaties, the limits of state sovereignty, responsibility of serious international wrongdoing, duties of non-recognition and cooperation among states, accountability for violations affecting humanity as a whole. The norm section of this application introduces the foundational concepts of educational purposes and provides structured access to the legal ideas that connect treaties, customary law, and international responsibility. International human rights law is sometimes described as a system based primarily on agreements between states expressed through treaties and customary practice. However, the modern human rights framework rests upon a deeper principle. Fundamental rights belong inherently to every human being and are not created by governments. The Universal Declaration of Human Rights affirms that freedom, justice, and peace in the world are founded upon the recognition of the inherent dignity and the equal and inalienable rights of all members of the human family. These rights arise from the dignity of the human person and therefore exist prior to and independent of the authority of any state. Following the adoption of the Declaration in 1948, the international community developed binding legal instruments that transform these principles into enforceable obligations. The most significant of these are the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, which together form the core of the international human rights framework. By becoming parties to these covenants, states undertake legally binding obligations to respect, protect, and ensure the rights recognized within them. Both covenants begin with the same foundational provision, Article 1, which recognizes the right of people to self-determination. This placement reflects the principle that legitimate political authority ultimately derives from the free agency and dignity of human beings. Through self-determination, people freely determine their political status and pursue their economic, social, and cultural development. Self-determination also includes the authority of people to freely dispose of their natural wealth and resources, ensuring that no people may be deprived of its own means of subsistence. This principle is reaffirmed later in the covenants to ensure that nothing within them may be interpreted as limiting the inherent right of people to fully enjoy and utilize their natural wealth and resources. Although self-determination is recognized as a collective right of people, its meaningful exercise depends upon the protection of fundamental individual freedoms, including freedom of thought and conscience, freedom of expression, participation in public affairs, and the protection of life and liberty. Within the international legal order, certain rules have attained the status of preemptory norms, jus cogens. These are fundamental principles of general international law from which no derogation is permitted. Any treaty or legal act that conflicts with such norms is considered void under the Vienna Convention on the Law of Treaties. Closely related are obligations erga omnes, meaning obligations owed toward the international community as a whole, because these obligations protect collective human interests, and states share a legal interest in ensuring their observance. The international human rights system also recognizes a category of non-derogable rights, rights that may not be suspended even during a time of public emergency. The ICCPR identifies several such protections, including the inherent right to life, the prohibition of torture or cruel, inhumane, or degrading treatment, the prohibition of slavery and servitude, the principle of legality in criminal law, the recognition of every person as a person before the law, the freedom of thought, conscience, and religion. These protections represent the core guarantee of human dignity, recognized as inviolable under the international law. Among them, freedom of thought and conscience protects the inner domain of human belief and conviction, which must remain beyond the coercive power of the state. Taken together, self-determination, preemptory norms, just cogents, obligations, erga omnes, and non-derogable rights represent the highest level of legal protection within the international human rights framework. They affirm that human rights are not privileges granted by governments, but inherent and inalienable rights belonging to every human being, which states are obligated to respect and protect. Just cogents refers to preemptory norms of general international law, recognized by the international community of states as norms from which no derogation is permitted. The modern definition is reflected in Article 53 of the Vienna Convention on the Law of Treaties, 1969, which describes a preemptory norm as a rule accepted and recognized by international community of states as a whole, as one that cannot be set aside by agreement and cannot be modified only by a subsequent norm of the same character. Unlike ordinary treaty obligations, just cogents norms does not depend solely upon state consent. They arise from fundamental principles considered essential to the international legal order and to the protection of humanity and the stability of relations between states. Key characteristics of just cogents norms include non-derogability. States cannot contract out of the rule, even by mutual agreement. Hierarchical superiority, conflicting treaties, or legal acts are considered void. Universal applicability. The norm binds all states regardless of treaty participation. Modification only by another preemptory norm. Ordinary law cannot override it. Under international law, when a treaty conflicts with a just cogents norm, Article 53 of the Vienna Convention provides that the treaty is void from its inception. Article 64 further recognizes that if a new preemptory norm emerges, any existing treaty conflicting with that norm becomes void and terminates. Just cogents norms are closely connected with the state responsibility. Serious breaches of such norms may trigger additional legal consequences, including duties of non-recognition, cooperation to end violations, and heightened international concern. While there is no exhaustive official list, commonly cited candidates for just cogent status include prohibitions against genocide, slavery, torture, aggression, crimes against humanity, and racial discrimination, are apartheid. The concept reflects the idea that certain legal principles protect fundamental values shared by the international community and therefore stand above ordinary agreements between states. A preemptory norm is general international law. It is a legal rule accepted and recognized by the international community of states as a whole, as a norm from which no derogation is permitted. Preemptory norms represent the highest category of the legal obligation within international law. They differ from ordinary treaty or customary rules because states cannot suspend, modify, or void them through agreement, reservation, or domestic legislation. Recognition of a preemptory norm does not depend upon anonymous consent, rather it arises from broad and representative acceptance by the international community as a whole, reflected through the consistent state practice, legal conviction, international judicial decisions, multilateral treaties, resolutions of international organizations, and the work of bodies such as the International Law Commission. Core elements typically associated with a preemptory norm include acceptance and recognition by the international community of states as a whole, protection of fundamental values essential to humanity and the international legal order, non-derogability, no treaty, agreement, or unilateral act may lawfully contradict the norm, hierarchetype superiority over conflicting rules of international law, modification possible only through the emerge of another norm possessing the same preemptory character. The identification of preemptory norms is an evolving legal process, rather than a closed list. International courts, tribunals, state practice, and scholarly analysis contribute to determining whether a rule has attained preemptory status. Preemptory norms therefore function as constitutional principles of the international legal system, establishing minimum standards of conduct that bind all states and limit the lawful exercise of sovereign power. The term erga omnes describes obligation owed by a state to the international community as a whole rather than to a specific state individually. In ordinary international law, obligations typically between particular states based on treaties or reciprocal arrangements. Only an injured state normally has standing to complain of a breach. Obligations erga omnes differ because they protect collective interests shared by humanity and the international legal order itself. The concept was articulated by the International Court of Justice in the Barcelona Tractate case 1970, where the court distinguished between obligations owed to individual states and to obligations owed to the international community as a whole. Because these obligations protect fundamental values, all states possess a legal interest in their protection and observance. Characteristics commonly associated with erga omnes obligations include: the obligation is owed to all states collectively. Every state has a legal interest in compliance. Responsibility may arise even where no single state suffers direct injury. The obligation protects fundamental community interests. Examples frequently cited include obligations relating to the prohibition of genocide, slavery, racial discrimination, aggression, and basic human rights protections. International law does not provide an officially closed or exhaustive list of just cogent norms or obligations erga omnes. Instead, certain rules are widely recognized in international practice, judicial decisions, and scholarly analysis as possessing preemptory or community-wide character. Commonly cited examples of just cogent norms include prohibition of genocide, prohibition of slavery and slave trade, prohibition of torture and cruel, inhumane, degrading treatment, prohibition of crime against humanity, prohibition of aggression and unlawful use of force, prohibition of race discrimination and apartheid, fundamental rules of international humanitarian law protecting civilians and prisoners of war, the right of people to self-determination. Examples frequently associated with obligations erga omnes include protection against genocide, basic human rights protections owed to all persons, prohibition of aggression, protection from slavery and racial discrimination, respect for self-determination of people. These examples emerge from multiple sources, including International Court of Justice jurisprudence, multilateral treaties with universal acceptance, United Nations resolutions and practice, international criminal developments, work of the International Law Commission. Because international law evolves, recognition of preemptory norms is understood as a continuing legal process rather than a permanently fixed catalog. The examples listed here are presented for educational purposes to illustrate how the international community has identified certain fundamental rules as protecting shared interests of humanity and the international legal order. International law does not rely on a single authority to declare a rule it just cogents norms. Instead, recognition develops through converging legal evidence showing acceptance by the international community of states as a whole. The following practical indicators are commonly used when assessing assessing whether a role has attained preemptory status. Widespread and representative acceptance. The rule is broadly accepted across different regions, legal systems, and political traditions, not limited to a small group of states. Recognition by the international community as a whole. The norm reflects collective legal recognition, rather than bilateral agreements or regional preference. Opinio juris states treat the rule as legally obligatory, not merely politically described or morally preferred. Non-derogability: states do not claim a lawful right to opt out of the rule, even during emergencies or by treaty agreement. Consistent reflection of international instruments: the rule appears repeatedly in widely ratified multilateral treaties, United Nations resolutions, international criminal law instruments, diplomatic practice and official statements. Judicial recognition: international courts and tribunals, particularly the International Court of Justice, acknowledge the fundamental character of the rule. International Law Commission analysis, draft conclusions, and commentary frequently consolidate state practice and clarify recognition of preemptory norms. Consequences of breach: serious violations typically trigger heightened international concern, duties of cooperation, and obligations of non-recognition. No single factor alone is decisive. Just Kogan status emerges when these indicators collectively demonstrate that the rule protects fundamental values of the international community and stands above ordinary international obligations. This checklist is provided for educational purposes to help readers understand the reasoning process and used in international legal analysis. When a rule of international law attains the status of a preemptory norm, just cogent, specific legal consequences follow for states, treaties, and international community. Invalidity of conflicting treaties under Article 53 and 64 of the Vienna Convention on the Law of Treaties. Any treaty that conflicts with the just cogence norm is void. States cannot create lawful obligations that authorize conduct prohibited by a preemptory norm. Non-derogation: states may not suspend or limit compliance with the just cogence norms, even by mutual agreement or during emergencies. Domestic law, national interest, or political necessity cannot justify departure from such norms. Duties of non-recognition: when serious breaches occur, other states are expected not to recognize as lawful situations created by violations of preemptory norms. This principle prevents illegal acts from gaining legitimacy through acceptance. Other forms of sexual exploitation on the sale of children. Since the First World Congress against Commercial Sexual Exploitation of Children, held in Stockholm in 1996, Japan has made considerable progress in combating child sex tourism by Japanese men, in particular in Southeast Asian countries. Japanese men continue nonetheless to generate significant demand of child sex tourism. A dedicated committee has been promoting the adoption of the Code of Conduct for the Protection of Children from Sexual Exploitation in Travel and Tourism. Japan is also a destination country for victims of trafficking in persons. Fraudulent marriages and employment are used by traffickers to bring their victims into Japan and to coerce them into sexual exploitation. Root causes and risk factors: gender roles and discrimination, the sexual commodification of children, and social tolerance, impunity, and poverty are among the root cause of various forms of sexual exploitation of children in Japan. Consumerism acts as a pull factor for sexual exploitation of children. For example, in JK Business, push factors include lack of job opportunities, a highly competitive society, and the poor human relationship and social skills of children. These multifaceted factors render children and youth vulnerable to sexual exploitation. Okinawa Prefecture, for instance, is particularly affected by poverty and has higher unemployment, divorce, and teenage pregnancy rates. The economic hardship endured and the consequent weakening of families render children particularly vulnerable to sexual exploitation. The special rapporteur noted with concern that children are treated as sexual commodities in the entertainment industry. as shown by the phenomenon of junior idols. These are children who pursue a career as photographic models and appear in sexualized attire in photo books and image DVDs. Some junior idols eventually enter the adult pornographic industry. They are popular with some teenagers and constitute a large market. Social tolerance for this type of commercial activity involving children is a major enabling factor of sexual exploitation. The Special Rapporteur regrets that the demand side of sexual exploitation of children is overlooked and that the focus is placed on the child victims and their families, even in well-intended public prevention campaigns. The Special Rapporteur urged the authorities concerned to shift the focus to the private sector that makes business out of sexual commodification of children. Measures to combat and prevent the sale of children, child prostitution, and child pornography. Legal framework. Japan has ratified key child rights instruments such as the Convention on the Rights of the Child and the Optional Protocol thereto on the sale of children, child prostitution, and child pornography, International Labour Organization's Convention Number 182 on the worst forms of child labour, and the Council of Europe Convention on Cybercrime. Japan has signed but not ratified the United Nations Convention against Transnational Organized Crime and the protocol thereto to prevent, suppress, and punish trafficking in persons, especially women and children, nor has it ratified the optional protocol to the Convention on the Rights of the Child on a communications procedure. The Act of the Regulation and Punishment of Acts Relating to Child Prostitution and Child Pornography and the Protection of Children, 1999, is a national law focused on criminalizing the sexual exploitation of children in Japan. The Special Rapporteur welcomed the adoption of the amendments to the Act by the National Diet in June 2014, which brought national legislation closer to international human rights norms and standards by criminalizing inter alia the simple possession of child pornography. The amendment was criminalizing inter alia. The amendment was the result of the arduous negotiations that lasted almost a decade, as well as the advocacy efforts of civil society and non-governmental organizations, teachers and parents, the Japan Committee for UNICEF, the private sector, and certain political parties. International pressure also played an important role in favoring the amendment. The amendment does not criminalize so-called virtual child abuse material, namely pornographic material that depicts realistic images of minors engaging in sexually explicit conduct. For example, manga, anime, and games which contain extreme child abuse material. Opponents argue that the criminalization of such material would be a violation of the right to freedom of expression, enshrined in Article 21 of the Constitution. They contended that a virtual child abuse material or visual depictions of non-existent persons did not harm real children and that no causal link had been established. Opponents also warned that of the risk of excessive police intervention against artistic freedom that could be labeled as dubious, and recalled the obscenity is already criminalized by the criminal code. They also contended that the purpose of law was to protect real children, and that efforts should focus on combating the sexual exploitation of real children. Opponents also criticized the attempts made to place stronger restrictions on visual media, which would have a particular impact on manga and anime culture, which is unique to Japan. Stakeholders in favor of criminalizing the production, offering, distribution, procurement, and possession of virtual child abuse material argue that according to international human rights law, the said material constituted child pornography and a violation of the rights of the child. They contended that children were harmed by the representation of violent sexual abuse contained in certain manga, anime, and games, and reflected a culture that tolerates child sexual abuse, even if there is no real harm. Virtual child abuse material fosters social tolerance of the exploitative acts that are depicted, contributing to the sexual commodification of children. The Special Rapporteur is aware of the importance of striking the right balance between freedom of expression and the right of the child. The latter should not, however, be sacrificed at the expense of a powerful and lucrative business. According to international human rights norms and standards, any pornographic representation of a child, regardless of whether the depicted child is real or virtual, constitutes child pornography. The aim is to provide protection against behavior that, while not necessarily doing harm to the child depicted in the material, might be used to encourage or seduce children into participating into such acts, and hence form a part of subculture that favors child abuse. In such cases, restrictions to the freedom of expression and to the right to privacy are based on grounds of morality and the prevention of harm to others. The ultimate goal is to achieve a society that does not tolerate acts that turn children into sexual objects or desire, which is a violation of the rights of the child. Nevertheless, the Special Rapporteur acknowledges that in certain cases, a difficult and delicate balance must be achieved to prevent the prohibition of virtual child abuse material from affecting the right to artistic expression, even though decisions on such matters should be subject to judicial review.